Welcome. I see that the list of attendees includes many professional colleagues and many who are new to me. Well, thank you for giving me your time today. I will try to give you something of significant value in exchange. I've been asked to introduce myself. I'm Bruce Clemens. I'm in my 47th year in the family law field. The details are in my resume, which is the last page of the electronic handout that you received. And that's something for you to use as a checklist for later, because it's exactly the PowerPoint slides that you're going to be seeing so that you don't have to take notes. So here's what led me up to today's program. Most of my professional career was at Jaffe and Clemens, handling large, complex, and heavily litigated dissolution of marriage cases, but 95%, 19 out of 20 were settled without a contested trial. But there usually was a significant burden to the client in every sense of the word burden, because the process was long and it was intense. Well, as my trial skills matured, I felt somewhat like a surgeon who did great surgery on people, but they might have avoided the surgery, at least some of them, if other medical diagnostics and treatments had been provided earlier. And that inspired me well over 20 years ago to begin my search to find better ways to settle litigated cases. My goal, of course, was to reach the same favorable results sooner and with less burden on the clients. I did this in my cases whenever possible. Well, professionally, several years ago, I retired from all litigation. I joined ARC as a neutral, and now I use some uncommon procedures to help parties who are already represented by attorneys all together settle earlier and settle better. So this is a two-part program today. Today, in the first portion, I'm going to try to forever change the way you look at and you handle the first 90 days of your litigated divorce cases. I know that's a tall order. I'm going to try. Tell you what the program today is not. It's not the presentation of cases or statutes or trial techniques or negotiation techniques. It's how to handle your litigated cases by using 4 early neutral procedures. This change in how to handle litigation at the early stage, it's a passion to me, really a passion to me. I'll try to tone it down. I can't promise. Those of you who know me know that's not always easy. In the second portion of the program, I'm going to present mediation roadmaps and mediation traps with solutions. And the second portion is mediations at any time, not just the first 90 days, also the later stage mediations, also the eve of trial mediations. Well, some of what you're going to hear today is going to remind some of you of what you already know. Other parts will give some of you a different perspective on things you already do, and others may introduce some of you to things you may not have previously considered or done. If there are any questions about this program, I welcome later email contact if you need. My email is bclemens90210@gmail. The 90210 is like the zip code. If you do, please send me a phone number, because sometimes phone is better than email. One more thing before we begin. Because this is not a program on how to negotiate, and yet we are all negotiators and we're always trying to improve our skills, I decided to supplement the program this morning by mentioning my favorite just published book, The 5-Tool Negotiator, The Complete Guide to Bargaining Success. The author is Russell Korobkin. He's a tenured professor at UCLA School of Law for 20 years. He's internationally recognized expert in the field of negotiation. But the reason I really like this book, it's a book for negotiators. It's not a book for scholars, although it is based on science and it's based on his more than 20 years of doing this. Well, he provided me with a pre-publication copy. I think it's available at Amazon soon. The book's as entertaining as it is educational. I'm going to hold up a copy of this book for you to see, because I'm going to try to show you, at least for me, I've got that in there, what it's like to get a book that's, hot off the press. No one else has seen it. It's got hot tips in there. And what's it like to get a book like that? Well, this is what it's like to get a book like that. It does have hot tips. And now we're going to switch over to the PowerPoint, which will just take a moment to do. Okay, so we start with the program, the name of what we just discussed. And we begin with the early family law litigation pivots, the 4 procedures. And I told you we're going to be going over them shortly. But first, I want to talk briefly about the word pivots. I chose the word pivots because it's a change in the direction from the usual or the expected. And that's what we're trying to have happen today. So the early family law pivots, we start with the word early. Early is essential. What does early mean? It's the first 90 days of litigation, not in some of your cases, in all of your cases. Why? It's before the fees increase. It's before the litigation positions harden any more than they've already hardened. It's before unnecessary events happen. There are 4 procedures with the neutral. I'll briefly tell you what they are, and then I'm going to do a little deeper dive. The first one is early mediation. That's settlement with incomplete discovery. When you think about that, it's really different from later stage mediation, because when you have incomplete discovery, you have incomplete facts. How do you settle? How do you do it safely? There is a way. It's a completely different process. The second procedure is something called early neutral evaluation, or ENE. And what it is the person retained to give an ENE report is going to give the probable trial result, not a suggested compromise. There are also other special procedures in the ENE process that facilitate settlement. So the third of the 4 is sequenced discovery. Now, early discovery targets key issues. And then there's an opportunity to add broad discovery later if necessary. But if you're going to settle early and you have no discovery, you have a problem. But if you do comprehensive discovery, you're not going to settle early. So you can sequence your discovery. The 4th is a science called dialogue facilitation. It's a focused discussion. It requires agreed, respectful procedures. It gives the parties an opportunity to safely address peripheral subjects. It avoids misunderstandings. Those are the 4 procedures. We start with early mediation and why it's different from later mediation. Well, of course, there's lower fees. That gives you something more to trade off. There's a shortened duration in the process. That's less pain. That's a good thing. There's more assets available to divide because you haven't had the litigation expenses I just mentioned. There's more income available to share because you don't have a payoff of attorneys. And I will get to the reason this is good for attorneys, not just good for clients. There's certainly less damage to children if the matter is resolved early. And as we've all experienced, litigation adds new litigation scars to the parties. Well, this is obvious, but only if you think about it. So let's talk about some of the risks. What if they're hidden assets and you settle early? What if you incorrectly value the assets? That's another risk. What if you incorrectly characterize the assets? What you think is community is separate, or separate is community, or mixed. These are the issues that you watch for, but you can resolve. What's the primary risk to the client? There's only one, a wrong result. That's pretty bad. What are the potential benefits to the client? They get a result better, faster, less expensive, and with reduced harm. It's actually not hard to get the clients on board with this. Let's talk about us, the attorneys. What are the risks to the attorneys? Well, you have a risk that your client could harm your reputation. Your client says, oh, you settled and now I wish you hadn't and you didn't know enough and how did you advise me? And that leads to a fee dispute. I don't know why you made me settle. I don't want to pay you. And nightmare of all nightmares, there's a malpractice claim. Well, the malpractice claim will almost certainly fail because in a mediation under the Kitarakis case, you can't get anything except the settlement itself out. And the Kitarakis case, and there's a couple of more, talk about the fact that if you have a claim and it's about what happened in the mediation, you just can't get the facts. And that pretty much shuts down malpractice. But here's the benefits to the attorneys. Realistically, you're going to get a better reputation. You're going to be recognized as one of the attorneys who puts your clients first, even apparently to your detriment, although I don't think it's to your detriment. The second thing is you're much more likely to be paid in full for every hour that you spend when you spend them efficiently and they don't pile up to the point that it's burdensome to the client. The third is professional satisfaction. I know we do this for a living, but why are we family law attorneys? It's more than that. We get the satisfaction that we have changed people's lives, we've helped them. And if you can remove pain that you've seen so much before in other cases, how much better can it be for satisfaction than that? And the last, of course, is future referrals. I agree. If this is the last case you're ever going to handle and it settles earlier, you'll make less money. But realistically, you have a lifetime in front of you. And when the word is out that you are the attorney who is very effective, putting the clients first, and yet you still have your trial skills, you still have your discovery skills, you're known that those are good, but at settlements, you're great. That can only help your practice. So there are some challenges to this. Sometimes you need a special agreement provision that can reduce certain risks when you're settling with incomplete information. I did a recent mediation. There was absolutely no trust. In this case, the wife thought the husband had hidden assets, and he was appalled at the accusation. He said he had no hidden assets, and it was a big, complicated case. And he just couldn't believe it was being challenged. And they were going to have a ton of discovery to do. And what I frequently do is I have a private conversation with each side first, mostly with the client directly. And a question came out: how positive are you that there are no hidden assets? He said, absolutely positive. I said, well, let me ask a question. You can give a warranty on that. He said, sure. I said, well, that won't do enough. How about you agree that if there are any hidden assets, separate or community, that your spouse didn't know about? So I don't mean her hidden assets. your hidden assets, they automatically go 100% to her, not 50%, 100%. If that's what it takes to get a settlement now, and you will save a lot of litigation expenses, is that something that you might do? And he said, absolutely. He said, you know, they still may not believe you. They still may want to do some checking. He said, not a problem. And the attorney looked at me, and I looked at the attorney, and I looked at the client and said, and your attorney will never advise you to do this. They can't. You have to tell your attorney, you're taking on this risk yourself, and you will not hold your attorney accountable. They settled. They were pleased with the settlement. It shook up the other side, and it caused them to rethink either there are no hidden assets or they are so well hidden, I'm never going to find them no matter how much I discover, but I may do some looking afterwards. So that's an example of what you can do in an early stage. Now, I like to prove things, the value of early. So here's the newsletter from the Harvard Business School. It's a good thing to subscribe to. It's all free. And there's early intervention, how to minimize the cost of conflict. You can see this everywhere. If you go locally to the Strauss Institute at the Pepperdine School of Law, where they do a ton of teaching and mediation, they have a national reputation. They're terrific. They all throughout, they talk about earlier is better. So let's go to the second procedure, early neutral evaluation. What is it? I'll tell you what it's not. It's not mediation. It's not even close to mediation. The person who you retain to do the early neutral evaluation is going to present a report, and it's not a recommended compromise settlement. Here's what it is. It's this person's prediction of the most likely result after a contested trial. And it's done in 9 steps. First one is you have to retain that neutral. And it's not somebody who's trained in how to get people to compromise. That's a bonus. But it has to be deep knowledge and deep experience in the major issues, because they're going to be presenting a report which is, here's the way the case appears, here's the most likely trial result as I see it. Then you have to agree to the rules and the procedures. This is step 2. Sometimes you just release the report, sometimes you switch over into a type of mediation afterwards, but everybody has to know. And they also have to know that it's confidential in the same way that a mediation is confidential. The third step is, and this is the heart of it, both sides present agreed facts, then they present disputed facts where they have different views. They present documents. If there are forensic accounting reports that have already been done, then they present those. And if they have a legal analysis, they present that. It's not the same as a full trial, but it's darn close. And the person doing the E&E has a pretty good idea what is likely to happen at trial. And that's the 4th step. So the E&E, the evaluator, prepares the written report, call it a judgment, except it's not binding. That report is never revised, but the process isn't over. Both parties will receive either, if it's in person, a sealed envelope with the report not to open, or they may get it sent to them electronically, password protected, but without the password. And that leads to the 5th step. And let me back to the 4th step. Let's assume that the evaluator says, you know, there's a dispute as to whether the asset is community or separate. And based upon the weight of the evidence, my guess is it's about 65% likely it's going to be separate and 35% likely it's going to be community if I get more and more testimony information. They don't get to say, well, why don't we compromise it 2/3, 1/3? The report is, it's separate property. Now, might not end up that way after a contested trial, but probably will. But they're not there to offer compromise. They're there to say this is the likely trial result. So now the parties are invited to pivot. They don't have to worry about changing the view of the evaluator because it's already written. And they can discuss, they can negotiate, and they do it before they read the report of the evaluator. They might reach a settlement. If they reach a settlement, they're not going to open the report. Nothing good comes from that. Just going to make somebody feel terrible and try to get out of the deal. But if there's no settlement, then the report is open and it's read by the parties and the attorneys and it's evaluated. And this report may cause both sides to accept it as an imperfect compromise. The view is, it's not quite right. I don't fully agree to it. But if it ends everything, I'll do it. Or both sides may negotiate a different settlement based on the report. They probably won't deviate a lot from the report, but they will. Or step 9, the report may not be accepted, may not result in immediate settlement negotiations, but it's not a failure. And it's not a failure because they will have seen what their case is about, what the strengths are, what the weaknesses are. They'll focus better on what to do in discovery. They may come back to settlement. But remember, everything is confidential. And this then leads to a potential, I don't know whether to call it a tactic or a procedure. You cannot refer to anything that happened in this process, the same as any mediation. But after it ends, including a day after it ends, you can send a settlement proposal to the other side. You cannot refer to what was done. And you can say, this is my settlement proposal. And by the way, it won't be disclosed to the court until the trial's over and we're to the attorney's fees part. But I think this is so reasonable, and I think not settling is so unreasonable that this matters. And you'd be amazed how that brings people back to the settlement table when one side is being unreasonably unwilling to accept the reality of what a compromise should look like and what a trial result does look like. Remember, I told you I like to prove things because for most of us, early neutral evaluation, never heard of it or slightly heard of it, never used it, never saw it, because that's pretty much what's going on. Well, the American Bar Association has a treatise on the whole subject of early neutral evaluation. It's a pretty good book. It's slightly expensive. You can go to Orange County. Here, I just took one of the many court forms in Orange County. This one's called Acknowledgement of Confidentiality, Early Neutral Evaluation, ENE session. Oh, it's there. It's around. My friends in Orange County who are family law attorneys, most of them have not heard of ENE, or if they have, they don't use it. Nobody that I've talked to has used it in family law there. There may be there, but I don't see it. And it's a regional issue because if you just go to Google and you type in early neutral evaluation, you'll see a ton of stuff. But the first thing you'll see is it's all over Minnesota family law courts. They have a huge footprint in Minnesota in family law. Early neutral evaluation really started in the 1980s in federal court in San Francisco, but that was for civil cases. Different states and different areas have converted it to use in family law, and it works very well. Minnesota, they just love it. Harvard recognizes early neutral evaluation as part of the family of alternative dispute resolution procedures. It's separate. It's not mediation, but it is ADR. It's international. Here's Canadian Research Institute. I'm pleading. I'm trying to sell you. This is a real thing. This isn't just an idea that got dreamed up. It's a real process to use, not in all your cases, but in some of them. And I'll give you one more. I looked at my malpractice policy for mediators that I have from Lloyd's of London. It says what I'm covered for. This is the standard form they use throughout all the United States with all the mediators they sell their insurance to. It says alternate dispute resolution. It says mediation. And it says E&E as a separate covered item. Well, if Lloyd's of London thinks that it's so significant it belongs in their standard form, I think that tells you something about early neutral evaluation. So let's now go to the third procedure, which is sequenced discovery. And what is that? It's the discovery problem at an early stage. I just did a mediation and presented an early problem. The mediation started, there was a house, not a lot of equity. There was a pension. They weren't really sure what the equity was. And they both had such terrible credit that if they sold the house, they were never going to buy another house, either one of them, and they weren't going to refinance the house. And so one of the questions was, do you sell the house or do you keep the house and trade it off against the pension? Problem is, they didn't know the value of the pension. There was nothing to do in the mediation. We shut it down immediately. We went into sequenced discovery. All we did was discovery on the value, this is a very limited budget case, the value of the pension plan. Hired the expert for that. Didn't even get a house appraisal other than going to Zillow and Trulia. And what happened? We had the problem, couldn't settle, needed the discovery, went, and traditional discovery would have been costly and time-consuming. So they did what I said, which was limited discovery, focused only on the issues. Now, you could do this yourself, attorney to attorney. The problem is, we're all battlers, we're all litigators, we're all advocates, and we also want to show our clients that we are there for them. It's so much easier when take an hour on the phone with somebody in the middle, and you can get this done. You also need a sequenced discovery agreement because there is a risk of losing your opportunity to do the additional discovery. Here's why. You do the limited discovery. You don't settle. Now you want to do the rest of your discovery. The other side says, oh, I need a protective order. So what are you talking about? I haven't done the discovery. Yes, you did. Look at the discovery you did. In a perfect world, no problem. In an imperfect world, a judicial officer might grant the protective order, but not if there is a one-paragraph agreement that says this is sequenced discovery. And if you think about what it really is with the later discovery, this is similar to case management. You know, you call or you go into court, and we used to go into courts, you go back into courts, and you have case management. The problem is that there's limited resources in the public court system right now. And while in theory, you should be able to call the judge and say, can you help us with this? And they really want to do it. They may not be able to. And sometimes you have to do it directly or sometimes with a neutral. And it's very simple because the neutral can just see in a minute when you tell them what the problem is. They see the missing evidence. So we now go to the fourth, which is dialogue facilitation. It's a science and it's an art. It uses special techniques to increase the likelihood of settlement. And even without settlement, it can lead to a litigation path that is less contentious. So how does it work? The facilitator seeks and structures the ground rules for speaking. They're pretty obvious. No profanity, no attacks. There was a recent mediation that I did, and both of these people were pretty fiery, but also one of them was very dominating, had much more knowledge about everything, and made sure that their spouse knew it. And in the private pre-meeting, I had to get that the ground rules were a couple of things. First of all, the 10% rule. Just in any relationship, anything, there's 10% that you just aren't going to like. If the first time in the mediation, the other side says something that drives you up a wall and you storm out, you're not going to get anywhere because nobody's that perfect. You have to give the other side 10% errors. Now, if they're constantly attacking, blaming, criticizing, and that's all they can do, that's going to kill the process. But you need an agreement from both sides. These are the ground rules. Don't leave. If somebody uses profanity and makes an attack, if it's occasional, you have to tolerate it. The other thing is the 50-50 rule. 50% of the speaking has to be done by each side, and that's really hard to take two people who have been married, and they're going to do the majority of the talking. And one says, I know about business, I know the money, I know all these things, and the other one rolls their eyes, and that's the entire history of the marriage. And they may know more. They may be smarter. They may have all the information. But they have to understand that if they do more than half the talking, there's not going to be a buy-in from their spouse, and there's not going to be a compromise. It takes a little while to get a buy-in on this, but that's part of dialogue facilitation. They have to identify the area of common interests. That's pretty easy to do. Usually begins with their common interest is, how do we turn off the lawyer meters? So sorry about that part, but why the common interest? Because when you resolve something, or at least agree on something, it's a good start. This is obvious at some level, you know this, but they've actually made it into a science. You then have to identify the area of opposing interests. And you really need to do, it can't be the elephant in the room nobody talks about, because it'll cast a shadow over everything else that happens. You have to deal with the hard stuff, but you have to deal with it safely. Then you have to get everybody to understand the risks and the benefits if this process succeeds in order to get the buy-in. And there's a lot more to dialogue facilitation. But I'm back into my proof again. Training and dialogue facilitation, you can go to University of Connecticut, and you'll find that they've got something where they list on their site 36 dialogue facilitation centers. They're independent organizations throughout the United States. I mean, this is real. It's international. Here's an international group that puts this on. And what you're trying to do, of course, is act early in every litigated case. But I have a couple more things to add, and then we're going to switch to the second part. If you go online and you look up a JAMS article, it's entitled An Underused ADR Tool, Neutral Evaluations in Family Law. So I'm not the first person that came up with this idea that this is a really good thing that just isn't being used enough in family law. if you go further on dialogue facilitation, if you look up at the University of Missouri, you get this all off of Google right away. They have a great 4-page discovery. The University of Oregon has a whole lab on dialogue facilitation. The University of Michigan, just want you to know it's real. So now we're going to go to part 2. Hopefully everybody's head is not spinning too much. Take a breath. We're switching into things to do in mediation, whether it's early stage, whether it's late stage, whether it's eve of trial. And the 5 things are there, the things you do before the mediation, the roadmaps and the traps in getting to an agreement in the mediation, the problem of getting from an oral agreement to a signed written agreement in a mediation, especially when it's video, making sure that your written agreement is enforceable, and anticipating buyer's remorse. So we'll start with the first one. Preparing your client in advance. You tell them what it's going to be, but you also send them a letter. I really think this should be 100% of the time. It's my view. I tried to do it, where you tell them about what their case is about, the risks, the benefits, what the law seems to be. And you do that so that if they make a fast decision in the mediation, and it does go fast, you will have told them well in advance what to consider. The third thing to do is, before you start your mediation, exchange your boilerplate provisions in advance with your opposing counsel, or if they don't want to exchange it, send your own. And finally, before you ever start the mediation, send your best settlement agreement or stipulated judgment form to the other side in advance, leave the blanks, and you can have much more accomplished there. Now, I want to first talk about boilerplate. There is no such thing as standard boilerplate or usual boilerplate. Boilerplate is substance. It's substance provision. There's no such thing as a standard custody order. It's substance. If you go to a mediation and you say at the end, and we'll add the boilerplate together as we agree. And if we don't agree, we'll have the mediator decide, or we'll have a judge decide. You have a lot of problems. Remember from first year law school, an agreement to agree is nothing. It's not enforceable. Well, an agreement to add standard boilerplate may not be anything, because there is no such thing as standard boilerplate. And if you have that agreement, it gets even worse. Suppose you have what you think is a 664 agreement, and it's signed, a deal memo, and it says we'll have boilerplate. Not only is the boilerplate potentially not enforceable, because I've seen this happen. Some trial judges, if you say, well, you've asked me to decide on the standard boilerplate, here it is, but others will say, I can't do that. I'm going to sign the judgment just with the provisions you added. I'm not adding any standard boilerplate. There's no standard boilerplate. Want to have a nightmare? Judge says there's no meeting of the minds. The whole agreement's out because you agreed on 7 things, but the 8th thing was boilerplate. And since I heard boilerplate is substance, you don't have an agreement. It's a set aside or unenforceable. And you can even end up with an appeal, because if the judge says, okay, here's the standard boilerplate, based on what evidence? No evidence? Appeal. Now, if you spoke with 100 judges, experienced family law attorneys, you would not get universal agreement on the things I just said as to what a judge would or wouldn't do with the problem of add boilerplate or what a mediator or an arbitrator would do. So I have a quiz. Is this boilerplate or are these substantive deal points? A general release. Some people think a general release is boilerplate. I sure don't. There's some lawyers who won't sign agreements without a general release. There's some who won't sign agreements with a general release. There's some who believe, most of us, it's a negotiated item. How about the waiver of Watts, Epstein, rights, etc.? You call that boilerplate. Last time I checked, that has to do with money. That makes it substance. How about revocation of your living trust? And you need to do that. It needs to say that. Is that a boilerplate provision or is it substantive? Sounds a little more boilerplate, but not for sure. How about when you get property like the house? Well, do you also get the insurance policy that goes with the house? Yeah, sure. Some people think that's boilerplate, but it could have a value attached to it. There could be premiums, which then leads to the fifth item. How about the proration of the prepaid premiums on the insurance that you think is boilerplate? You get the house, you get the insurance that goes with the house. There's paid up premiums on the insurance, and it's not limited to house or real estate insurance. Is that boilerplate? It's substantive. It's not a lot of money, it's substantive. And then here's the killer. Removal of one party from the mortgage on the property that's given to the other party, even though the other party is going to assume and be obligated to pay the mortgage. Why is that so crucial? Because if you and your spouse are on the mortgage and then you get a divorce, you transfer the house to your spouse, your spouse keeps the mortgage for the next 20 years. Well, for the next 20 years, when you apply for a new mortgage on a new piece of property or any other credit, you will be asked, do you have any other outstanding loans in your name? And you do. And because sometimes qualifying for a loan is based on formula, mechanics, ratios, you got a big problem. Sometimes at a contested trial, there'll be an order which says, if you get the house and you assume the mortgage, you have to get the other spouse off the mortgage within 90 days, or else you have to refinance and get them off that way. And if you don't do that, then you have to sell the property. And if you can't qualify to buy another property, that's crucial. But that's not an uncommon result. But here's one that in a recent mediation, there was a minor child. It was an impossibility because of bad credit to refinance or to buy another house. And the trade-off was, and it was a negotiated item, for the next 4 years, the outspouse, the one who was not getting the house, would allow their name to stay on the mortgage so that the child could continue to stay in the same residence. It happened to be a 14-year-old child, can stay in the same residence. At the end of the 4 years, because it should be prepared in advance, if at the end of the 4 years, they're not off the mortgage, then the house is sold by court order in the judgment. And it was a negotiated item. Certainly wasn't boilerplate. So the next question is, how long should a mediation last? Well, that's something you need to agree to in advance, because one of the answers is it needs to last as long as it takes, including at 2 a.m, if that's what it takes. Or you need agreed upon quitting time. There's nothing more frustrating than you're in the middle of a mediation. It's 2:30 in the afternoon and somebody says, I have to go now and pick up the children after school, when children used to go to school. And it's perfectly understandable but it wasn't addressed at the beginning. And now with Zoom, there is a view as to whether it is better to have a number of short mediation sessions. They might only be 1 or 2 days apart, rather than long mediation sessions. They both have something to say for them, and you'll each get to figure out what you think is best for you. Here's another problem we're having in mediations that are on Zoom. You have an oral settlement agreement. Nobody's there to sign it. Well, and they'll say, or even if it's an in-person, well, we'll write it up and we'll exchange it and get it signed next week. All you have is an oral agreement. And remember, once again, from law school, an oral agreement is not worth the paper it's written on. It's not enforceable. And you can't even talk about what the agreement was in mediation, period. End of story. The statute says you can't. The California Supreme Court says you can't. There is a narrow exception that's illusory. And the reason I say it's illusory is it's Evidence Code section 1118. It says you can make an oral agreement in mediation that's enforceable so long as, and there's 4 steps, and the 4th step is that you sign it within 72 hours afterwards. Now, before you say, well, then what does that do, if anything? Here's the difference between an Evidence Code 1118 oral agreement signed within 72 hours and a mediation that ended, and then the parties outside of mediation 72 hours later signed an agreement. The deal is, if it's a mediation agreement and it's challenged, it's virtually bulletproof because you can't get into the evidence of what was said and not said in the mediation. But if it's not a mediated settlement, it is a settlement agreement outside of mediation, then you have some of those opportunities to challenge. But if it's an Evidence Code 1118 mediation, even though it's signed 72 hours after the oral agreement and the mediation ended, you still have a mediated agreement. You have alternatives, of course. If you sign right away, then you're locked in. On the other hand, if you sign right away, it's more likely to make a mistake, or at least that your client thinks you made a mistake. There's no good answer to that. But let's go to what you can do to get an agreement signed in a Zoom era. You could print it out. If everybody's got a printer, or somebody has a printer. You can ink sign it. You can fax it. Or you can scan and email the signed document. That's the best. You can use DocuSign. That's, by the way, a little bit expensive unless you're regularly using it. Adobe PDF free reader, not the one you pay for, the free reader has just added an electronic signature feature. It's slightly challenging to use, but we like that it's free. Or you can use other electronic signature software, and California Rule of Court 2.257 allows that. It's not as good as ink signed. It could be, but not 100% as good. Here's some other things that have been done. You print it, you sign it, you take a photo of what you signed with your cell phone, you send a picture. Well, in theory, that ought to be good enough to get a judgment, but there are possible technical defenses to anything which is not printed and ink signed. And the reason is because signing isn't what makes something enforceable. It's sign and deliver. You sign an agreement by yourself. Even if you pick up the phone and tell somebody you signed it, other than an estoppel question, then you change your mind. You haven't delivered it. It's like delivering a deed. Delivery matters. Well, if you print, ink sign, fax scan, I think that's delivery, the same as if it had been messengered. I think DocuSign is delivery, but you always get that question of, it's an imperfect world. You have opposing attorneys, you have judges at the trial level, judges at the appellate level, you have arbitrators, and they see things differently. And as they see things differently, then what you're going to do with seeing it differently is you're going to have a risk. I dealt with the last thing, which is buyer's remorse after signing an agreement during the mediation. It's actually more global than that. It's buyer's remorse. We all have this. I thought it was so important, it was worth just putting big print, one slide, because it's fairly universal. Buyer's remorse is not going to go away. There will always be people who they make an agreement, they feel some type of pressure, their spouse, their kids, their lawyer, whatever it is. And even if they don't, they just talk to somebody the next day, 2 days, 5 days later, they're sorry they did it. And that's when they come to you and they say, I want to get out of this. This was a terrible deal. What can we do? And many of us are litigators, and there are ways sometimes to try to get out of an agreement. The problem is when the client says, you, my lawyer, let me down. And that's why, and I'm going back to the early parts of prepare your client for buyer's remorse. Tell them it's common. Tell them they may or may not have it, but it's common. And they need to be aware of that. And that's why you tell them in advance in writing what their case is about, what their risks about before they start in the mediation, not when you make an agreement in the mediation and then afterwards you send them a letter that describes what the whole thing is about before. And having done that, and having shown them that they had all the time they needed, not only that, they saw the boilerplate in advance. You didn't just send your proposed boilerplate to the other side. You showed it to your client, you answered their questions, and you showed the draft agreement. Now, it might not have the amount of support, but it had the support provisions. It might have had how real estate or savings are going to get divided. It had blanks for those, but it had the words in there. And your client will know one of two things. Either they will know that you did everything humanly possible to be the best lawyer for them possible and to make sure that they were as knowledgeable as possible, so that if they had buyer's remorse, it's something they generated from within that was unstoppable. They will also learn quickly enough that if they are truthful and tell anybody, friends, families, a malpractice attorney, anybody, what their unhappiness is, and then they show what you provided to them, the response is always going to be, what more could they have done? And that's what we end up doing. So I'm now going to stop with the PowerPoint and get back to saying hi to all of you again. We covered a lot of territory in this hour. I really hope you will use these procedures in all, not just wait till there's a problem, all of your litigated family law cases. The analogy I use is, imagine if your medical plan in life was, you never go to a doctor, you never have a test, you never do anything until you're sick. And you say, oh my goodness, something's really, really, really terrible. You may have gone 30, 40 years in your life, you never went to a doctor, and then you rush into the emergency room. It's not a very good medical plan. If the first time you look to use these procedures is when your case has fallen apart, blown up, and then you say, I got to get a mediator, I've got to talk to the other attorney about special type of discovery, all these things, you'll be a very good advocate in the contested trial, but it might not have been a necessary contested trial. If you do this, you'll be surprised at how well some of these things work. They're not theories. You'll benefit as much as your client will benefit. You are going to get increased satisfaction. It is uncommon. I know there's going to be some caution here, but there's wonderful people to do. There's retired judges, there's experienced mediators, there's even a trusted other attorney that the two of you could, on each side, could use to do some of these things. I told you at the beginning, I'm passionate about the change in the family law field. I changed it internally the way I ran cases. Some of you had cases against me. We're a little surprised that there was so much voluntary discovery sent in advance. Didn't seem to fit the image you might have had of me. It was all part of the same thing. If you have any questions or need further clarifications about this program, as I said at the beginning, send me an email. It's bclemens90210@gmail.com. And I will respond. Send me a phone number. I might respond by phone. And I've got to tell you, this career has been a dream for me. I'm now in late part of my life, and I'm trying to be as much in the give back mode as I can. So whatever I can do that helps any of you, that's what I'm here to do. I don't mean to hire and pay me to help you. I mean, if you're having problems with what I just said with this, call me. And I think we've come to the end of our hour, and I thank you so much for trusting me with your time today.